Hello everyone. Hope you had a great Diwali. Today we are going to start from page 8, which starts from a meaning and definition of a company. Meaning and definition of a company. Let's now understand what is a company and how it is positioned. The word company is derived from the Latin word com means with or together and panis means bread, and it originally referred to an organization of persons who took their meals together. In the leisurely past, merchants took advantage of festive gatherings to discuss business matters. Nowadays, the company form of organization has assumed great importance. When they form their business relation, they form a company. In popular parlance, a company or firm denotes an association of like-minded persons formed for the purpose of carrying on some business or undertaking. A company under law is a corporate body and a legal person having status and personality distinct and separate from the members constituting it. It is called a body corporate because the persons composing it are made into one body by incorporating it according to the law and clothing it with legal personality. The word corporation is derived from the Latin term corpus, which means body. Accordingly, corporation is a legal person created by a process other than natural birth. As a legal person, a corporate is capable of enjoying many rights and incurring many liabilities of a natural person. An incorporated company owes its existence either to a special parliament or to company law. Public corporations like Life Insurance Corporation of India, SBI, etc. have been brought into existence through special acts of parliament, whereas companies like Tata Steel Limited, Reliance Industries Limited have been formed under the Company Law, that is Companies Act 1956, which is replaced by the Companies Act 2013. In the legal sense, a company is an association of both natural and artificial persons and is incorporated under the existing law of a country. In terms of the Companies Act 2013, that is Act number 18 of 2013, a company means a company incorporated under this Act or under any previous law, that is Section 2, Clause 20. In common law, a company is a legal person or legal entity separate from and capable of surviving beyond the lives of its members. A company is rather a legal advice for the attainment of social and economic end. It is therefore a combined political, social, economic and legal institution. Thus the term company has been described in many ways. It is a means of cooperation and organization in the conduct of an enterprise. It is an intricate centralized economic and administrative structure run by professional managers who hire capital from the investors. Lord Justice Lindley has defined a company as an association of many persons who contribute money or money's worth to a common stock and employ it in some trade or business and who share the profit and loss arising therefrom. The common stock so contributed is denoted in money and is the capital of the company. The persons who contribute it or form it or to whom it belongs are members. The proposition of capital stock to which each member has contributed entitled in his share. The shares are always transferable, although the right to transfer them are restricted. Nature and characteristics of a company. Since a corporate body, that is a company, is the creation of law, it is not a human being. It is an artificial judicial person that is created by law and is clothed with many rights, obligations, powers and duties prescribed by law. The most striking characteristics of a company are discussed below. The first one is the corporate personality. A company incorporated under the Act is vested with a corporate personality, so it bears its own name, acts under name, has a seal of its own, and its assets are separate and distinct from those of its members. It is a different person from the members who compose it. Therefore, it is capable of owning property, incurring debts, borrowing money, having bank account, employing people, entering into contracts and suing or being sued in the same manner as an individual. Its shareholders are its notional owners and do not own anything in it except the ownership of shares issued, and they can be its creditors simultaneously. A shareholder cannot be held liable for the acts of the company even if he holds virtually the entire share capital. The shareholders are not the agents of the company, and so they cannot bind it by their acts. The company does not hold its property as an agent or trustee for its members, and they cannot sue to enforce its rights, nor can they be sued in respect of its liabilities. Thus, incorporation is the act of forming a legal corporation as a juristic person. A juristic person is in law also conferred with rights and obligations and is dealt in accordance with law. In other words, the entity acts like a natural person but only through a designated person whose acts are processed within the ambit of law. Within parenthesis, the case law of Shiromani Gurudwara Prabhannak Committee versus Sri Samnath Das AIR 2000 SCW 139 is given. Case example. The case of Salomon versus Salomon and Company Limited 1897 AC 22. The above case has clearly established the principle that once a company has been validly constituted under the Companies Act, it becomes a legal person distinct from its members, and for this purpose, it is immaterial whether any member holds a large or small proportion of the shares and whether he holds those shares as beneficially or as a mere trustee. In the case, Salomon had for some years carried on a prosperous business as a leather merchant and boot manufacturer. He formed a limited company consisting of himself, his wife, his daughter, and his 4 sons as the shareholders, all of whom subscribed to 1 share each, so that the actual cash paid as capital was £7. Salomon sold his business, which was perfectly solvent at that time, to the company formed by him for the sum of £38,782. The company's nominal capital was £40,000 in £1 shares each. In part payment of the purchase money for the business sold to the company, debentures of the amount of £10,000 secured by a floating charge on the company's assets were issued to Salomon, who also applied for and received an allotment of 20,000 £1 fully paid shares. The remaining amount of £8,782 was paid to Salomon in cash. Salomon was the managing director and 2 of his sons were the other directors. The company soon ran into difficulties and the debenture holders appointed a receiver and the company went into liquidation. The total assets of the company amounted to £6,050. Its liabilities were £10,000 secured by debentures, £8,000 owing to unsecured trade creditors who claimed the whole of the company's assets, that is £6,050 on the ground that as the company was a mere alias or agent for Salomon, they were entitled to payment of their debts in priority to debentures. They further pleaded that Salomon as a principal beneficiary was ultimately responsible for the debts incurred by his agent or trustee on this behalf. Their lordships of the House of Lords observed, the company is a different person altogether from the subscribers of the memorandum, and though it may be that after incorporation the business is precisely the same as before, the same persons are managers and the same hands receive the profits, the company is not in law their agent or trustee. The statute enacts nothing as to the extent or degree of interest which may be held by each of the 7 or as to the proportion of interest or influence possessed by one or majority of the shareholders over others. There is nothing in the Act requiring that the subscribers to the memorandum should be independent or unconnected, or that they or any of them should take a substantial interest in the undertakings, or that they should have a mind or will of their own, so that they should be anything like a balance of power in the constitution of company. The next case example that is given is the case of Lee versus Lee's Air Farming Limited, 1961 AC 12 PC. The above case illustrates the application of the principles established in Salomon's case that we just discussed. In this case, a company was formed for the purpose of aerial top dressing. Lee, a qualified pilot, held all but one of the shares in the company. He voted himself the managing director and got himself appointed by the articles as chief pilot of the company at a salary. He was killed in an air crash while working for the company. His widow claimed compensation for the death of her husband in the course of his employment. The company opposed the claim on the ground that Lee was not a worker, as the same person could not be the employer and the employee. The Privy Council held that Lee and his company were distinct legal persons which had entered into a contractual relationship under which he became the chief pilot, a servant of the company. In his capacity of managing director, he could, on behalf of the company, give himself orders in his other capacity of pilot, and the relation between himself as the pilot and the company was that of a servant and master. Lee was a separate person from the company he formed, and his widow was held entitled to get the compensation. In the effect, the magic of corporate liability enabled him, that is Lee, to be the master and servant at the same time and enjoy the advantages of both. The decision of the Calcutta High Court in reply to Condoli Tea Company Limited, that is 1886, ILR 13 CAL 43, recognized the principle of separate legal entity even much earlier than the decision in Salomon vs. Salomon and Company Limited case. Certain persons transferred a tea estate to a company and claimed exemptions from ad valorem duty on the ground that since they themselves were also the shareholders in the company, it was nothing but a transfer from them in one name to themselves under another name. While rejecting this, Calcutta High Court observed the company was a separate person, a separate body altogether from the shareholders, and the transfer was as much as a conveyance, a transfer of the property, as if the shareholders had been totally different persons. The next case example is New Horizons Limited versus Union of India, AAR 1994, Delhi 126. The experience of a shareholder of a company can be regarded as experience of a company. The tender of the company New Horizons Limited for publication of telephone directory was not accepted by the Tender Evaluation Committee on the ground that the company had nothing on record to show and it had the technical experience required to be possessed to qualify for tender. On appeal, the rejection of tender was upheld by the Delhi High Court. The judgment of the Delhi High Court was reversed by the Supreme Court, which observed as under. Once it is held that NHL, that is New Horizons Limited, is a joint venture as claimed by it in the tender, the experience of its various constituents, namely TPI, that is Thomson Press India Limited, LMI, Living Media India Limited, and WML, that is World Media Limited, as well as IIPL, Integrated Information Private Limited, has to be taken into consideration if the Tender Evaluation Committee had adopted the approach of a prudent businessman. Seeing through the veil covering the face of NHL, it will be found that as a result of reorganization in 1992, the company is functioning as a joint venture wherein the Indian group, that is the TPI, LMI and WML and Mr. Arun Puri, holds 60% of shares and the Singapore-based company IIPL holds 40% shares. Both the groups have contributed towards the resources of the joint venture in the form of machines, equipment, and expertise in the field. The company is in the nature of partnership between the Indian group of companies and the Singapore-based company who have jointly undertaken this commercial enterprise wherein they will contribute to the assets and share the risk. In respect of such a joint venture company, the experience of the company can only mean the experience of the constituents of the joint venture, that is the Indian group of companies, that is TPI, LML and WML, and the Singapore-based company IIPL, that is this is New Horizons Limited and another versus Union of India 1995. With this we come to the end of this audiobook. The next characteristic company as an artificial person we will see in the next audio. The thing is, like, if you keep the audiobook short, it will be easier for us to listen and understand the concept. Thank you. Stay safe.